biotechnology, and the presenters is myself, Dexter, and also Aric. So we'll be covering a few things about biotech. Really, we're gonna cover what is biotech. We're gonna cover a case that was previously mentioned in class, and also like the impact and what happened 10 years, 20 years after biotech has this after biotech was after the diamond case. And so let's start off with covering what is biotech. So biotech is the use of living systems and organisms to develop or make useful products or any technological application that uses biological systems, living organisms, or derivatives thereof to make or modify product or process for specific use. So, what does this mean? Really, just to put it in short, this just means that we're using living things, basically to kind of transform them and to create, to create a to create some sort of item or thing to have it, towards doing specific uses that we can do. Really, some example that we have was like a Monsanto case where they would take charge of the seeds and whatnot. So they changed things in order to make it work for them. Going on. So biotech provides a wide range of knowledge and tools to support development efforts and give rise to some important global policy issues. Biotech is relevant to the work of many UN agencies whose mandates include capacity building at the global, regional, or national levels in food, agriculture, health, and environment, energy, industrial development, and security. So what biotech has done, and what it's actually doing is, furthering what we have now. We're taking use of what is out there and furthering that and improving on it, and as you can, or making it worse, as however you want to put it. But it is, this is biotech, the use of living systems and organisms. So I'll be giving it over to Aric, who will be covering the diamond case.
Okay, so the Diamond versus Chakrabarty case basically started when Andan Chakrabarty, who was a PhD who worked at General Electric, actually genetically engineered a bacterium that is capable of breaking down crude oil, which is which can be used in oil spills when oil tankers basically um, have accidents, which is used to break down that oil that is spilled into the ocean. So the case started when Mr. Chakrabarty was trying to patent his creation, or this generically engineered bacterium, uh, under the United States Code Section 101, which states that it provides patents to people who invent, discover any new and useful manufacture of or composition of matter. So the Mr. Chakrabarty's attempt in trying to patent this bacterium led towards the case of Diamond versus Chakrabarty. So basically, the question that is stated in this case is that is the creation of a live human-made organism patentable under the Title 35 of the United States Code Section 101? The Supreme Court's decision was yes. In a 5 to 4 decision, the court explained that while natural laws and physical phenomena, abstract ideas, or newly discovered materials are not patentable, a live artificially engineered microorganism can be patentable under the Title 35 of the United States Code. Basically, this generically engineered bacterium that Mr. Chakrabarty engineered, was a composition of matter, uh, which was not directly made out of, which did not actually directly come from nature, but it was generically engineered. So it falls under the human-made organism category, I believe. So this case actually marked a turning point in patenting, which led towards the ability for uh, corporations or people who create who generically engineer um, organism or anything that comes from nature. There gave them the ability to patent whatever they created. So it leads towards the Monsanto case and the other cases of Monsanto in patenting generically engineered organisms. So I'll lead it to Dexter so he'll explain the impacts of Diamond versus Chakrabarty.
Okay, so Diamond versus Chakrabarty. So the Chief Justice Warren Berger wrote the decision for the case. Who was joined by Stewart, Blackman, Rehnquist, and Stevens. So really, what Berger wrote that the question before the court was narrow is a narrow one, and the interpretation of 35 U.S. Code 101, which says that whoever invents or discovers any new and useful process, machines, manufactures, or composition of matter, or any new and useful improvement thereof, may obtain a patent. Therefore, subject to the condition and requirements of this title. So with Justin Warren Berger, he really, he as stated, it was a narrow approach. The question was narrow enough so that it gave them the ability for them to be able to patent something like this. So, Justin Berger, Justice Berger really kind of really interpreted down to the T. You guys can look at it more into the case if you guys want to. There's a whole bunch of resources online if you guys wanted to know more of what Justice Berger said in his opinion. So the impact of the case paved way for patenting of genes by declaring genetically engineered bacteria to be patentable material. Um, and like Aric said earlier, the case really showed this case kind of showed the revolution in biotechnology, and the as a result after this case they issued so many patents, thousands of patents, and formation of hundreds of new companies because of this U.S. Supreme Court decision and what they have decided. I know these facts are kind of from about 10 years ago. And you can see the numbers, it has exploded. So as of December 2003, 473 biotech companies has been created. But you can see that it's a 10 years difference now, so you can imagine right now that number probably has grown a lot higher now. In 1992, the amount that they were spending on biotechnology was $8 billion. And in 2003, it's $39.2 billion now. So really what this shows is just the vast majority of research that they're putting into biotechnology and be able to control some of these, some of these living organisms, what they're going to do. And in biotech, in 2003, you can see it was 10 years ago now. And you can see that number has gone up. I don't know the exact number, but that number has gone up tremendously. Um, and as of 2003, again, there was a $311 billion in total value of capitalization from each of these companies. As with it was 25 years after the case. This is the study that they did. A few people did the study 25 years later. I think they'll be coming up with another study with what happened in the future. So let's keep going with the impact of the case. So Douglas Robinson and Nina Medlock, they did this research, 25, what happened 25 years after the case. They quoted, although there are moral and ethical issues involved in the manufacture of living things, patents themselves are not designed to address such issues. The patents is really, the patent office is Just to determine novelty and non-obviousness, issues of morality and ethics are best left to organizations specifically tasked to deal with those issues. So what they're basically saying is the patent office does not interpret anything. They just issue patents. There's so many issues regarding the patent office recently in the past 10 years, but now they're saying that it's not these Doug Robinson and Medlock are saying that patent office is not interpreting. They're just issuing patents. So they wanted to kind of not put the blame on the patent office, but to take it up with organizations who deals with these issues. So the history of the United States patent law. This is what really hits both me and Aric. Um, as stated, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is found in the U.S. Constitution, Article 1, Section 8, Clause 8, I believe. This was created in the era of Industrial Revolution, is what we should keep in mind. And the framers, they thought about the future and what the future might hold. It was really to see, to kind of help people with it, and with new discoveries. Really what we're saying is just providing information for you guys. But the history of the United States patent law, looking at what they had in the U.S. Constitution, is really interesting to see that they added this somewhere in there. So the Patent Act of 1952, this is the act that I really wanted to bring up. What this act is set standards for what can be patented or not. An amendment to the 1952 Patent Act clarifies that cultivated spores, mutants, hybrids, and newly found seedlings were patentable. So the U.S. Supreme Court affirmed that plants are protectable by patents in the case by Gem Agriculture Supply Inc. versus Pioneer Hybrid International Inc. What this Patent Act is basically covering, just an amendment to show that the seedlings are patentable. And you can really look what the Patent Act is. It's really a really long act to go through. We just wanted to kind of mention that. In regards to biotechnology, the seedlings part, is patentable. So I think we're running up our presentation. I hope you guys enjoyed it. Here are our resources. This is a few of the resources that we have used. But yeah, I really hope you guys enjoyed it.
Oh, I just would like to add on that go back to the Diamond versus Chakrabarty case, which there's that part under the United States Code which states the composition of matter. Actually, and I'll yeah, it's the composition of matter basically that led towards the success of the case. So, in addition to the impact on a much more global policy level, the idea of global policy, patenting genetically modified organisms basically would can help and contribute into food security in other developing nations, and even helping other people in the United States too, by improving uh, agriculture and other industries that would rely on this patenting that would rely on this idea of patenting genetically engineered organisms. So
And just a few things to leave off of, really, if you really want to look at it, I really encourage you guys to look at the 1952 Act, and also some cases from the Monsanto Act, from Monsanto. The 1952 Act, they wrote something in 2011, and I encourage you guys to look for it yourself, the history of the 1952 Act, because there's a few things that happened after, but I won't cover in this presentation because I want you guys to search it up. So, if you guys have any questions, feel free to email Aric or Dexter, and we'll be able to cover something. We'll be able to help you guys out with it.
or hopefully, if you have any questions, you could bring it up in class, so we could maybe have a short discussion about it if possible. Yeah.
Okay. All right. Thank you,
Yeah.
everyone.
Thanks.
Thanks for listening.